For years, when you talked about data privacy, one name dominated the conversation: Europe's GDPR. It was the undisputed champ. But guess what? A new heavyweight, coming from the world's most populous country, has just stepped into the ring. We're talking about India's Digital Personal Data Protection Act, and let me tell you, it's about to shake things up for everyone. So let's just start with this question. Who really controls your digital life? I mean, it sounds simple, right? But the answer? It's getting more and more complicated every single day. Think about it. Every tap, every click, every scroll, you're creating a digital footprint. And the fight over who owns and controls that footprint, well, it's going global. And it is heating up.
All right, so in one corner, we've got the reigning champ, the gold standard, the EU's General Data Protection Regulation. You know it as GDPR. And in the other corner, we have India's brand new challenger, the Digital Personal Data Protection Act, or DPDPA for short. We've got two massive, powerful rulebooks trying to govern one digital world. So let's get into it and break down what this all means. Okay, first step, Bharat meets Brussels. And this is really the perfect way to frame it. We're starting with a high-level look at two, very different philosophies. This isn't just about dry legal text. No, this is a reflection of totally different cultural and economic priorities. It's a fascinating matchup. So let's set the scene real quick. Back in 2018, GDPR just landed, and it immediately set the benchmark for the entire planet. Now, fast forward to August 2023, India, we're talking a digital-first nation, over 1 billion people, rolls out its own massive data law. And that brings us right here, to today, where global companies are basically stuck in the middle, trying to figure out how to navigate two powerful and very different sets of rules. And this, right here, is where we get to the core of the issue, the real philosophical divide. I mean, sure, both laws are trying to protect you. That's the goal. But they come at it from completely different angles. And it really all boils down to one single question. What gives a company the legal right to use your data in the first place? And that question leads us directly to this key legal term, lawful basis for processing. Honestly, the best way to think about it is like a legal permission slip. A company absolutely has to have one of these before they can even think about touching your personal info. If they don't have that permission slip, they're breaking the law. Simple as that. Okay, and check this out, because this is where the two paths just completely split. Under GDPR, a company has a few options, a few different permission slips they can use. Your consent is a big one, of course, but there are others, like if it's necessary for a contract or if they have a legitimate interest. But DPPA, it pretty much throws all of that out and puts all its eggs in one basket: consent. Just that. It's a much simpler approach, for sure, but it also gives businesses way less wiggle room. So, we've talked philosophy, but what does this actually mean for you, for your data, and for your rights? Let's take a look at what's inside your personal privacy toolkit, depending on which law you're under. First things first, what are we even talking about? What counts as personal data? GDPR, which comes from this long European tradition of fundamental rights, gets kind of detailed. It has a broad definition, sure, but then it carves out this special, extra protected category for what it calls sensitive data. Think health info, political beliefs, that kind of stuff. DPDPA, on the other hand, is really aiming for simplicity to help its massive digital economy grow. So it keeps things straightforward. All personal data is just personal data. No special categories. Now, if you're under GDPR, you get a really powerful privacy toolkit. It's pretty comprehensive. You've got the right to see your data, the right to correct it if it's wrong, and the right to have it deleted. You can even pack up all your data and take it with you to a competitor. That's called data portability. And this is a big one, you have the right to just say, nope, and object to your data being used for stuff like direct marketing. Okay, so now let's look at the DDPPA's toolkit.
You still get those core essential rights: access, correction, and erasure. You can see your data, fix it, and delete it. But notice what's not there. The right to data portability? Gone. The right to object? Also missing. And that's a pretty big deal. It means you, as an individual, have fewer direct controls over how your information actually gets used. All right, let's talk about something that's absolutely critical: protecting kids' data. And I've got to say, this might be one of the biggest and most important differences between these two laws. The approaches they take are just starkly different. So, over in the EU, under GDPR, the general age of digital consent is 16. Now, individual countries can lower that down to 13 if they want, but the bottom line is, if you're younger than that age, a company has to get verifiable consent from your parents before they can process your data. India, though, takes a way stricter approach. The DPDPA sets a hard line. The age of consent is 18, no exceptions. And for anyone younger than 18, it's a total ban on tracking, on behavioral monitoring, and on targeted ads. It's an incredibly protective rule, but you can imagine it's also a huge challenge for any platform that's popular with teens. Okay, so we've covered the big ideas and the rights you get. But what about the other side of the coin? Let's flip this around and look at the rulebook for businesses. What are their obligations? And more importantly, what happens when they mess up? Let's just run through some of the key operational differences here. First off, just the words they use are different. What the EU calls a data controller, India calls a data fiduciary. Same idea, different name. Next up, reporting a data breach. GDPR is super strict. You've got 72 hours. DPDPA is a bit more flexible right now. No hard timeline. And finally, who's the ref? In the EU, it's a whole network of national authorities. In India, it's one new central body, the Data Protection Board of India. And let's talk about the penalties, because you better believe both of these laws have teeth. DDPPA can hit you with fines up to around 28 million euros. That's a lot of money. But GDPR's fines are, well, they're legendary. It's up to 20 million euros, or, and this is the kicker, 4% of a company's global annual revenue, whichever is higher. For the big tech giants, that can literally mean billions of dollars. The financial risk is just, it's absolutely massive. So, as we start to bring this all together, what's the big takeaway? What's the big picture here? Well, what we have are two incredibly powerful legal frameworks. They're both trying to solve the same fundamental problem, but man, they are taking very, very different roads to get there. You know, when you strip it all away, the ultimate goal is pretty much the same: giving you, the individual, control over your digital identity. The difference is all about context. These laws didn't just appear out of nowhere. They were shaped by their homes. GDPR was born from Europe's really deep focus on fundamental human rights. DPDPA was born from India's national priority of building a trillion-dollar digital economy and making it easy for businesses to thrive. And this brings everything right back down to earth, to the real world. Just picture a fintech company based in Bangalore. For all of its users in India, it's got to be laser-focused on DPDPA's consent-first rules. But wait, for its customers in Germany or France or anywhere in the EU, it also has to follow every single one of GDPR's much broader requirements. And this isn't some classroom example. This is the daily, complicated reality for any business that operates on a global scale. Which really leaves us with one big final question to chew on. As more and more countries follow in the footsteps of Europe and India and start writing their own data rules, what kind of digital world are we building? Is it one that's genuinely more protected and safer for all of us? Or are we just creating a ridiculously complicated patchwork quilt of rules that's impossible for anyone, users and companies alike, to navigate? It's definitely something to think about.